Good morning, everyone. Welcome to Assembly Judiciary. Welcome to those in Las Vegas, here in Carson City, as well as anyone watching through Nellis or on YouTube. With that, Committee Secretary, will you please take the roll?
Assembly members Cole. Here. Dahlia. Here. Gonzalez. Here. Gray. Hansen. Here. Hardy. Here. LaRue Hatch. Here. Marzola. Present. Moore. Here. Nadeem. Present. Orenlicker. Here. Roth. Here. Urick. Here. Chair Miller.
Here. And please mark Assemblymember Gray present. He is here. Thank you so much. So with that, just a few reminders, reminding everyone to turn down their electronics. Also that we will have public comment at the end of today's hearing. Those wishing to make public comment, I will provide the phone number right now. This number would also be used if you choose to testify on a bill. The number is 1-888-475-4499, and the meeting ID for today is 893-6375-4952. When making public comment or testifying, we ask that you keep your comments to 2 minutes. We also ask presenters presenting bills to keep their presentations to 15 minutes. With public comment, you are able to submit written comment up to 24 hours after the adjournment of the meeting. With that, I think that we have covered all of our housekeeping issues, so I will go ahead to our first agenda item today. We are hearing 2 bills. The first bill on the agenda today is Assembly Bill 192, which makes various changes relating to real property. And so with that, I will invite Assemblymember Backus up to get us started. And Assemblymember, I ask that you introduce your co-presenters, and once you're all settled in and ready to begin, just please proceed.
Thank you so much. Good morning, Chair Miller and members of the Committee on Judiciary. For the record, I am Shay Backus. I'm the representative for Assembly District 37. Today, it is my pleasure to introduce Assembly Bill 192 with Mackenzie Warren Kay of the law firm Brownstein Hyatt Faber and Schreck, Michael Buckley of Fenimore Law now. Both are down in our Las Vegas offices, as well as Newman Trowbridge Professor John Levitt at LSU, Paul M. Hebert Law Center, and Jane Sternecki, Legislative Counsel for the Uniform Law Commission. Both of them will be appearing on Zoom. I am also here in my capacity as a Nevada Commissioner for the National Conference of Commissioners on Uniform State Laws, often referred to as the Uniform Law Commission, or ULC. I was appointed to the ULC in accordance with Chapter 219 of the Nevada Revised Statutes. The ULC was established in 1892 to provide states with nonpartisan, well-conceived, and well-drafted legislation. ULC's deliberative and uniquely open drafting process draws on the expertise of commissioners, but also utilizes input from legal experts, advisors, and observers representing the views of other legal organizations and interests that will be subject to proposed law. ULC stays up to date by addressing important and timely issues. And so AB 192 includes the Uniform Easement Relocation Act and the Uniform Mortgage Modification Act. The Uniform Easement Relocation Act was approved by the ULC in 2020 to modernize a common law rule that gives easement holders absolute power to common law rule that gives, to restrict development of land burdened by an easement. The Uniform Mortgage Modification Act, approved by the ULC in 2024, clarifies and simplifies the law governing common modifications of residential and commercial mortgages. And with this, at this time, I will turn our presentation down to Las Vegas, starting with Mrs. Kay.
Thank you very much, Chair Backus. Chair Miller, thank you for hearing the bill. Mackenzie Warren Kay, Warrenkay. We did not plan the pink, but that's a happy little coincidence. Assemblymember Backus, you're never one to shy away from a complicated subject matter, so we thank you for carrying the bill. Members, just for brief background about the real property section, this is a group of real estate attorneys. They're practitioners in this area of law. They're experts. Each year they bring a bill as cleanup to try to make some changes they think would improve this area. A quick disclaimer. So this legislation has been approved by the Board of Governors of the State Bar of Nevada, and that authorizes the executive committee to advocate in favor of AB 192, but it does not represent the position of the Board of Governors of the State Bar of Nevada, the general membership of the State Bar, or of the general membership of the real property section. We also did want to let members know that there is a friendly amendment that has been posted to Nellis, as well as a summary chart that helps condense the bill. And with that, I will turn it over, Chair, with your permission, to Mr. Buckley, who has chaired the section for the last 18 years. Thank you.
Morning, Assembly members. Michael Buckley of Fenimore Law. What I'd like to do is walk you through each of the bills. The Uniform Easement Relocation Act is sections 2 to 32, and the Uniform Mortgage Modifications Act is section 33 to 50. I go through the UERA first. As is typical with the uniform law, it has a number of definitions. What I'd like to point out is that in the amendment that we prepared, which has been provided to you, we made a couple of changes to the uniform law definitions. Number one is we eliminated a reference to common interest communities. As you know, they are heavily regulated under NRS 116, and they are developed. So we've excluded them from being able to modify easements in a common interest community. We've also added definitions of public entity and a public entity easement and a public road. We wanted to make sure that the Easement Relocation Act did not allow relocation of public utility easements or easements that are held by political subdivisions. Section 22 is the basic section that it permits the relocation of an easement, and it also states which easements cannot be relocated, which includes public easements and public utility easements and conservation easements. One thing I'll also make a note of is that the Uniform Act has a definition of conservation easement. Nevada has already enacted the Uniform Conservation Easement Act, and there's a definition there, so we thought we should just use the definition we already have. Section 23 describes the findings that are required to locate the easement. Section 24 deals with the civil action that must be filed in order to do this. And just in general concept, it's important. The basic idea is that the easement can only be relocated after the filing of a civil action where the court makes the findings that are set forth in the law. Section 25 deals with the order that the court must enter, and we've added an amendment here that we got from the Utah Act, which was approved, and that is if an easement was created by a recorded subdivision map, a process for doing that, for amending that. Section 26 describes the cost that a person has to pay. We've added an amendment. We thought that there were additional expenses that might be incurred that the persons seeking to move the easement would have to pay. Section 27 imposes an obligation of good faith in the relocation process. Section 28 describes the document that must be recorded that will effect the relocation. Section 29 creates general rules regarding the relocation. For example, the relocated easement is not a new easement. Section 30 is a provision that says that the parties cannot agree in advance that an easement can't be relocated. Section 31 and 32 are customary Uniform Act provisions that dealing with electronic signatures and uniformity of interpretation. The Uniform Mortgage Modification Act, sections 34 to 50, once again, we have definition sections in 35 to 46. 47 deals with the applicability. And one of the things I think important is subsection 2 of section 47. This act does not affect laws governing mortgages, statutes of limitations, recording laws, priority of tax liens, statute of frauds. Section 48 is the key section of this bill. What this does is, and again, the big picture, under common law, if a mortgage, if after a mortgage is recorded, another lien is recorded afterwards, a modification of the first mortgage is not, the priority is not affected if the modification does not adversely affect the junior lien. What Section 48 does, it creates 10 safe harbors, that these safe harbors are, these modifications will not affect the priority. And one of the reasons that we thought impressed me certainly is that one of the purposes of the act is that it facilitates a modification of a loan that's in trouble, and it works as a foreclosure preventive. And these types of modifications include like an extension of the maturity date, or a decrease in the interest rate, a capitalization of unpaid interest, forgiveness or forbearance, and requirement dealing with escrow amount. And with that, and then again, it has the general provision that deals with electronic signatures and uniformity of interpretation. And with that, I'd be happy to answer any questions. Thank you.
Thank you so much.
Chair, before we go up there, do you mind if I just ask if Mr. Levitt, the reporter from the ULC, had anything else to add?
Please, yes.
Thank you. Thank you very much for allowing me to address you today. I'm very excited that the Nevada Legislature is considering this act. The ULC worked on it for several years, and it represents the culmination of a lot of work of judges, lawyers, and professors around the country. I'd just like to make two additional points. As some of you may know, the Nevada Supreme Court at one point, in an interesting opinion, expressed admiration for the restatement third of servitudes, which was in some ways the inspiration for this act. But because there was some confusion about how far and what kinds of servitudes the restatement applied to, the Nevada Supreme Court limited its holding in a case called St. James Village. This act will make sure that the same principle that was embodied in the restatement will now apply to all easements, even easements that have whose location was originally fixed by the instrument creating the easement. And the key part of the act that really will expand the utility of easement relocation for Nevada is found in Section 30, subpart 3. I also wanted to address briefly the
Sir, before you do that, I feel it's necessary to let you know that when you say Nevada, all of our ears turn off. So we are proud of our state of Nevada. So that way, and if you could see everyone in the room right now. So again, I'm not going to ask you to repeat everything you just said, but so that our ears are open and we can hear you, it's Nevada. So.
Oh, I apologize. I have been to Nevada a few times lately, and one of my best friends is the dean of the medical school there. So
Okay, so then I will blame them for not, yes. Okay, thank you so much. Continue.
Great. And I wanted to address briefly the amendments to protect public easements and public easements held by municipalities. This is an interesting thing that several states have addressed. I just wanted to assure members of the committee, I read hundreds of cases about easement relocation when we were working on this act, and there was never an instance in which a servant estate owner tried to relocate a public road or a publicly held easement. And I think that's because in most cases where that's necessary, the parties work out an agreement. So I don't think it was ever a big problem, but certainly the amendments you have added will make sure that doesn't happen. And if a servant estate owner needs to try to relocate a publicly held easement, I'm pretty confident that parties will work out a mutually satisfactory agreement. And the act still provides for that. So I think the amendments are helpful, but I'm not worried about that problem at all, really. I hope that helps. Thank you.
Thank you so much. And you really read hundreds of documents on easement relocation. Sounds riveting, was
Yes,
it?
there were many going back to the 19th century. Yes.
All right, we're very impressed. Thank you so much. With that, we do have a few questions. We will open it up from Assemblymember LaRue Hatch.
Thank you, Chair, and thank you so much for being here today. When we consider laws, I always consider the cost, and in any law, there's a cost of time and considering the bill and hearing time, and I just want to make sure it is outweighed by the benefit to the community. So I just wondered if you could, in just simple language, just say why this is needed to help folks back in our districts.
Sure. If in many cases, an easement was created decades, sometimes generations ago, by parties who never saw that there would be a problem with development of a servient estate. And what sometimes happens is that cities grow, new opportunities for development occur, and someone who owns land burdened by an easement sometimes can be easily frustrated by the refusal of the easement holder to move an easement. And sometimes that easement holder can take advantage of his sort of short-term monopoly power to really frustrate what could be a very beneficial development for the entire community. And what this act does fundamentally is that it gives the servient estate owner a chance to go to court if an easement holder is being completely unreasonable in negotiations over relocation of an easement. And it allows the court to say, yes, the servient estate owner can provide you with the same functional benefit of an easement if we move it to a slightly different location. You won't be harmed at all. And this will allow the servient estate owner to do something useful, valuable with his property. Sometimes it means just moving a road a little bit further away so that they have more safety for their family and their children. This was an example we just heard about in Virginia last week when we were hearing testimony. Or it could be because you could build some new housing, build a new commercial development, something that's going to create jobs and provide opportunity for people in the community. So I see this as an important kind of pro-development a piece of a state's legal landscape that's going to make it easier to develop property, do things that are beneficial for a community, and still protect the easement holder's legitimate interests in the use of an easement, instead of using it to exploit a servant estate owner to try to get what we call a ransom payment, sometimes in real estate development. I hope that's helpful.
Thank you, Professor John Levitt, Shay Backus, Assemblywoman for District 37. For the record, I just kind of wanted to give like a simple, easy visual of kind of what Professor Levitt was talking about. Imagine if you just had two parcels of land. Our cities and our communities in Nevada are growing, and so we're expanding outwards. And one of those lands had a road going right through it, but you happen to acquire that land with this driveway right through it. That's accessing the other piece of parcel. It's so that that second parcel that utilizes that road doesn't hold that, like your land, hostage, and you could go to court to simply move that driveway to maybe the outer skirts of your property so you could fully use your property. Hopefully that gives you a better visual on easements.
Thank you.
Thank you. Our next question is from Assemblymember Cole.
Thank you very much, Chair. Thank you for the presentation, and I very much appreciate this issue. I'm actually a proud member of the real property section of the Nevada Bar, so I just wanted to put that out there. I've got a question for you on the carve-out in section 12.1 where you talk about the United States. My question is specifically to federal reservations of easements and rights-of-way that are later patented into private ownership. And I'm just wondering if this could possibly allow us a way for a landowner who acquires property to get rid of some of those easements for the exact same reasons you just described.
Thank you for the question, Shay Backus, for the record, by and through Chair Miller to Assemblywoman Cole. I'm going to send this back up to Attorney Mr. Buckley because it was something he added in there, and I think he can explain it for why it was put in there.
Yes, thank you. Members, Michael Buckley from Fenimore. I think the answer to the question is who holds the easement? And once the property has been developed, and I think, you know, in real life, what happens is all these properties have a patent easement around the border of the parcel, and those are routinely vacated in the development process by the local cities or counties. So we added them. I think we were more concerned about Nevada political subdivisions, but once the beneficiary, it's the beneficiary that has the right to use the easement. So it's really not the United States anymore. That the United States created the easement, but it's no longer the beneficiary. The one case I think of in Nevada was, and it dealt with this, and the property owner said, well, you City of Las Vegas can't require a roadway on our property because it's a United States patent. And the Nevada Supreme Court said, no, the city is the beneficiary of that. So it's up to the city, who the holder of the easement is. I hope that answers your question.
May I have a follow-up, please? Thank you so much. So I work for clients of mine at the Apex Industrial Park, and so what I've seen is the patented lands there will have, say, a easement or a right-of-way that was granted when it was still under ownership of the federal government, and it was for, say, access to transportation or to communication sites on top of a hill. And so then later that land was patented, and the owner would like to move that road, that dirt road that goes through the straight in the middle of their property to the outskirts. And they are required to go to every single one of the communication sites to make that happen. And there might be 50 on that tower.
The Assembly member Michael Buckley from Fenimore. I think the way the bill reads, the intent is that if it is a utility easement, I think regardless, and maybe Professor Levitt could clarify, but if it is a utility easement, our intent is that would not be able to be relocated. It doesn't prevent the parties from negotiating relocation. And I'm kind of familiar with one, I think it's out in Henderson, where there's a road up to the top of the mountain. And but I think you would also probably need to clarify. I doubt that 50 communications folks are the beneficiaries of the easement. They're probably relicensed under some grant from the easement holder. I think there's probably only one easement holder.
Thank you very much. I would love to follow up with you on this outside of the hearing, if that's okay. Thank you.
Happy to.
Our next question is from Assemblymember Hardy.
Thank you, Chair. Thank you for being here and bringing this bill. And Mr. Buckley, I just have to say it's always good to see you. You were my dad's law partner for many, many years, Mel Close. So I always enjoy seeing you again. It's been a long time.
One of my favorite, the Hall of Fame, Legislator Hall of Fame.
Yeah, yes. So thank you. It's good to see you. So my question is, I just want to make sure I'm understanding the bill. So currently, if people want to address their easements and such, that's done like mutually through mutual agreement between the parties. And so this would they still be able to mutually agree to it, or would they have to go through the court, or is this just like another way to do this?
Assemblymember Hardy, Michael Buckley. No, it's certainly there's freedom to negotiate. Obviously, I think what's interesting too, and I think there's a definite cost to going through this civil action, but you're able to move the easement through the civil action, but would be likely expensive. Just any kind of litigation is expensive. So certainly there actually sort of creates a some pressure on the parties to reach an agreement. And there's definitely no reason why parties can't agree.
Thank you so much for that. With that, I don't see any more questions, so I will go ahead and open it up for testimony. So beginning here in Carson City, if there's anyone that would like to come forward and testify in support of Assembly Bill 192, asking that you keep your comments to 2 minutes. Also, I neglected to say earlier, please make sure before you speak that you say your name and the first time spell it so that we have it correct on the record. So if there's anyone here in Carson City that would like to come forward and testify in support? Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone approach broadcasting. Will you open the lines, please?
If you would like to testify in support of Assembly Bill 192, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 192, please press star 9 now. Chair, the public line is open and working. There are no callers choosing to testify in support at this time.
Okay, thank you. Then I will open it up for opposition testimony. Anyone here in Carson City that would like to come to oppose Assembly Bill 192? Not seeing anyone? Is there anyone in Las Vegas that would like to oppose it? Also not seeing anyone. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 192, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in opposition at this time.
Thank you. Then I will go ahead and open it up for neutral testimony.
Good morning, Chair Miller, members of the committee. For the record, I'm Michael Alonso. I'm here on behalf of AT&T. Thank you for a few minutes this morning. AT&T is neutral on the bill. We've had conversations with the sponsor and also, I believe, some conversations with the proponents as well. This is a complicated bill, and AT&T's lawyers are still looking at it, and they qualify as a public utility in certain aspects, and so it's just really trying to make sure that we're not missing anything, and we'll continue to work with the sponsor and the proponents to get to where we need to get to. Thank you.
Thank you, Chair Miller and committee members. Misty Grimmer, Grimmer, for the record, representing Cox Communications. Similar to Mr. Alonso, we've been working with the bill sponsor and the proponents to work on what is included in the definition of a public utility. Video service providers are traditionally not considered a public utility, but we operate and use the easements and the rights of way to provide services to the public the same way a public utility does, and so we often seek the same protections as a public utility. Thank you.
Good morning, Chair Miller and members of the committee. My name is Jeff Rogan, R-O-G-A-N, and on behalf of Clark County, we're in the neutral position today. We want to, because of the second conceptual amendment that's been proposed. We were opposed to this because easements that are held by governments are a little bit different than easements that are held by private entities. Our easements are generally intended for use by the public, as mentioned, roadways and sidewalks, but they also might be drainage ditches that are intended to make sure that your neighborhoods don't flood. And there already is a process in NRS Chapter 278 when a person wants to be unburdened by an easement to seek a vacation of that easement. And that has to happen through a public process where the public can come and give comment as to whether the easement still serves them a benefit. And we think that should be maintained. If we were subject to the court process, there wouldn't be that opportunity for the public to come out and offer comment as to why they still use an easement or an easement is still needed. That is why we wanted this amendment, and we're very happy that the proponents actually brought it forth before we even spoke with the Assemblywoman. So again, thanks to the proponents and the Assemblywoman for exempting us out.
Thank you so much. I don't see anyone else here in Carson wishing to testify in neutral. Is there anyone there in Las Vegas that would like to testify in neutral? Not seeing anyone. Broadcasting, will you open the lines?
If you would like to testify in neutral for Assembly Bill 192, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in neutral at this time.
Thank you so much. Then I will welcome the bill presenters back up for any final remarks.
Thank you, Chair Miller. Shea Backus, Assembly District 37. I just wanted to pop back up. We had already taken care of a lot of the concerns that made working with stakeholders very easy. Section 22 is what kind of details and addresses public entity easements, as well as we're hoping to work on the language regarding public utilities, as how Mr. Buckley explained. Nevada was a little unique in that respect. But I want to thank not only you, but the committee members for considering this bill today, as well as my helpful presenters from Mr. Buckley, the state's property section chair, Ms. Warren Kay, as well as our wonderful Uniform Law Commission staff, Mr. Necky, even though she didn't have to do much today, but I'm sure she is overly prepared, as well as Professor Levitt. So with that, I would just urge your support of Assembly Bill 192. Thank you.
Thank you so much. Then I will go ahead and close the hearing on Assembly Bill 192 and open the hearing on Assembly Bill 197, also sponsored by Assembly Member Backus. I will give you a few moments to get your co-presenters settled and kind of ready. Also, just reminding everyone before you begin to please introduce all your presenters and then state your name before you speak for the first time, and then please spell it so that we have it correct for the record. And so, Assembly Member, we couldn't hear what you're saying. Are you all settled? Okay. Welcome to Assembly Judiciary. This is a pleasant surprise. I did not know you were the co-presenter. And with that, this bill is no. Okay, so let's go ahead. So whenever you are ready, please proceed.
Thank you, Chair Miller and committee members. Once again, I'm Shea Backus, representing Assembly District 37, and with me will be my primary co-sponsor, should this committee allow me to amend my co-sponsor into this bill, Assembly Member Greg Hafen of District 36. Thank you for the opportunity to present Assembly Bill 197. This is a bipartisan bill that seeks to find the appropriate balance between government power and the people's right to privacy. Specifically, AB 197 would require government entities to keep 501c nonprofit information confidential, including donor, member, and volunteer data, except information which is already required by law to be made public as part of an annual filing or other disclosures. And it would prohibit government entities from collecting sensitive information related to 501c nonprofit membership, volunteer list of donor records, unless there is a legitimate reason to do so, as outlined in Section 2, subsection 3 of the bill. As this bill is fairly short, I will quickly walk the committee through its sections. Section 1 simply adds certain information described in Section 2 to the list of information that is not a public record. Section 2 requires, with certain exceptions, a governmental agency to keep confidential any personal information in the records of the governmental agency that identifies a person as a donor, member, or volunteer of a nonprofit organization. The bill further prohibits, with certain exceptions, a governmental agency from 1, requiring that any person or nonprofit organization provide the agency with personal information that identifies a donor, member, or volunteer of a nonprofit organization. 2, releasing, publicizing, or otherwise publicly disclosing personal information that identifies a donor, member, or volunteer of a nonprofit organization. Or 3, requesting or requiring a current or prospective contractor or grantee to provide a list of nonprofit organizations to which the contractor or grantee has provided support. Importantly, Section 2, subsection 3 of this bill lays out all the appropriate and allowable instances where a government entity can request or release these records when acting under a legitimate mandate in law. We spent several months in 2023 working with agencies and departments to build a comprehensive list of allowable uses. So a lot of work has been done in putting that list together. If a governmental entity operates outside of the allowable uses in Section 2, subsection 4, an individual who has been harmed by a violation of this law may bring a civil action to obtain certain relief, including injunctive relief as the court deems appropriate, 2, cost incurred in bringing the action, including without limitation, reasonable attorney's fees, and 3, damages in amount not less than $1,000 for a first violation, $5,000 for a second violation, and $10,000 for a third violation, unless the court determines it was reckless or intentional violation, then a court may award treble damages. I want to reiterate that in order for a person to prevail in court, the bill requires a plaintiff to demonstrate actual harm caused by a governmental entity's actions. Section 3 of the bill makes a conforming change to prohibit the Secretary of State from collecting or disclosing any information that directly identifies a person as a donor of a financial support to a nonprofit organization. Critically, this measure does not change or weaken any current disclosures required by state campaign finance, nonprofit, or corporate registration laws, and AB 197 explicitly permits for any other legally required disclosures from nonprofit causes. The proactive privacy protections in AB 197 are intended to prohibit rogue office holders and agencies from operating outside their legal jurisdiction and weaponizing the powers of the office against people or organizations they may otherwise dislike. I want to emphasize that this bill is a proactive, preventative measure to protect Nevadans. A version of this policy has passed in 20 other states over the last 7 years, including most recently passing unanimously in Colorado. Finally, we have proposed a technical conceptual amendment that has been uploaded to Nellis that cleans up some of the wording in subsection 4 of Section 2, but also I want to additionally recognize that we have been working with stakeholders as recently as yesterday, specifically Clark County, finding language that could be written a little more clearly to make some sense. And hopefully you have those paper copies on your desk and we can get that over to the committee manager to have uploaded for Nellis for the public to see as well. With that, we stand ready to answer any questions that you have, and I will also turn it over to Assembly Member Hafen.
Thank you, Madam Chair. Thank you, committee. And before we got started, Chair Miller, I was just talking to Assemblywoman Backus about how she sat on the left and I sat on the right, that she was strategically doing that. She asked me not to say that, but the reason that I bring that up is because...
But the bill's right down the middle.
It is right, the bill is right here in the middle.
The bill's right there in the...
And what you're going to see when people testify in support, that it is both sides of the aisle that do support this. And so I felt that it was important for me to be here today and sit on the right side of the dais here. And so I just want to say thank you to not only Assemblywoman Backus and the committee here, but also all the stakeholders that spent hours and hours working on this to get to a point that almost everybody's satisfied, and we have agreed to work with the last stakeholder that I believe is in neutral still, but to just finalize the language and get it to where everybody is comfortable with the direction that this is headed, because it is important to everyone. So thank you, Madam Chair.
And thank you so much for joining us today. With that, I will open it up for questions. We will begin with a question from Assemblymember Cole.
Good morning. Thank you to both of you. I appreciate you both being here. My question is in section 4, page 8. When you're determining the first offense, second offense, third offense concept, is that per person in the agency? Is it per agency? So if you had two people that did it from the same agency, it would be a second offense? Or does it go with the person?
Before I speak, I mean, my instinct is, but I want to look at the language, is that it's not intended if there was multiple people that it was the same breach. So say you had, Assemblywoman Shay Backus for the record. Thank you, Assemblymember Cole, for the question. Basically, it's intended so there's not repeat offenses. I could understand, like, say if there were two people sharing information and they collectively released it, to me, that would be a one offense. And I think that answers your question. What it is if there's a pattern of like repeat behavior and it's constantly getting leaked out, and it's that first offense, the second offense, the third offense.
Thank you. Our next question is from Assemblymember, I'm sorry. Do you need to continue? Yes, please. And then we'll go to Gray.
Thank you, Chair Miller. The technical amendment hopefully will make that language clearer.
Thank you. Assemblymember Gray?
Thank you, Madam Chair. I appreciate this, but I do have a concern with, having been involved in county government, stuff happens. Is there any kind of safe harbor provision that would prevent something from, inadvertently? I mean, if there was no malice intended, it's kind of broad, and especially with the harm portion. There's no real definition of what that, if an inadvertent disclosure, what kind of harm it would cause. So, does that make sense?
Okay. Thank you, Assemblymember Gray. Shay Backus, Assemblymember for District 37 for the record. And it's amazing because I believe you sat on Government Affairs. Oh, you did not. I thought this was your question from last session. But anyway, so one of the key things with harmed is before there's this legal concept of judiciability that basically in order to bring a cause of action, you have to have standing, you have to be the person that was injured, and there was a lot of ambiguity that people felt last session when this bill had been heard, and I want to note for the record it was passed with bipartisan support originally, but the harmed factor was added explicitly into this language, so there was no ambiguity as if you're harmed, you're the person that's injured. So like you've suffered damages. So the best example that I could give is if someone was releasing your information that a government entity received, and it didn't fall into one of our numerous exceptions that I think that now go to P, if not probably more, basically, but it was a situation, and it's more like that intent to the harm that, like those individuals, but it would be that information got out there, the person somehow like maybe lost their job because they were a donor of a national nonprofit that their employer didn't agree with or something along those lines, then there would be actual harm because they've like suffered their loss of wages potentially. So that would give you like damages personally to go ahead and bring the suit. Did you want to add them?
Gregory Hafen, Assemblyman District 36. And I just wanted to add, this was brought up by a number of the municipalities, and that was some of their concerns. And so we actually worked with General Counsel to try to hone in the language in the amendment specifically. I kept arguing with General Counsel they're going too far, adding too much protections. However, I think that they came up with some really good language in the conceptual amendment that do touch to exactly that, because that was one of the concerns from the municipalities that we worked really hard to address.
Can I clarify, ma'am? Yes, please. So the clarification, Assemblyman Hafen, was that with regards to the safe harbor or the other portion?
Yeah, I can go ahead. Thank you, Assemblymember Gray, Assemblymember Backus, for the record. It was to tighten up harmed, in just so that, like, when we're referring to the General Counsel, that's from the Governor's Office, is the General Counsel that we were working with on making sure that was clear, because that was one of the challenges we ran into with this. The prior bill had been vetoed, and it was the concerns over the harmed language. So we've been working on that with them. The other thing is there's no like real safe harbor. One thing that I think would be a good visual would be a situation where when you look at section 2 of the bill, I believe it is, let me find the key language that I want to turn your attention to. You have in here where it says except as otherwise provided in subsection 3, which is our litany of really well worked out exceptions to various situations is that government entities shall maintain in a confidential manner any personal information that identifies. And so it requires the government entity to maintain this confidential information. And I always think about like a situation of a hacking. And if someone got hacked, I think it would be reason for them to go to the court and go, we did everything we could do to keep this information confidential, but some superpower got all this stuff and released it. That's a different situation. But then what if you had a board who was apprised of their weak systems that were in place and they just didn't do anything about it? Are they really keeping your information confidential? And I think that's a good distinction to give a visual of what the bill intends.
Thank you, Assembly Member.
Thank you so much. Our next question is from Assembly Member Ordlicker.
Thank you, Chair, and thank you for bringing the bill, and I look forward to more joint efforts by the two of you during the session. I appreciate the concern you're addressing, but sometimes people exploit these kinds of protections, and I'm thinking of the so-called dark money 501c4s. It looks like you've addressed that in one of your exceptions where any report or disclosure required by Chapter 294A of NRS. Is that right? Am I reading that if we wanted to come back and say, here are some organizations that are exploiting the protections for donors, and I'm on page 6, line 14. So it looks like you've given us authority to address, if we wanted to, address the dark money non-disclosures, and people don't know who's behind those organizations. Am I reading that correctly?
Thank you, Assembly Member Orlichter, for the question. When we're looking at Section 2, subsection 3, subpart C, that is an exception to the rule, and it would be only limited to what those disclosures are. So, and if I remember correctly, I believe it was our Secretary of State that wanted to make sure that exemption was explicitly set forth. So this bill will not impact any disclosure rules under 294A.
Right. So am I correct then? If we wanted to address the dark money, we could amend 294A and we'd be okay. Because we don't address that now, right? So if we wanted to, going forward, all we need to do is amend 294A and we're home free.
Thank you, Assembly Member Orlichter. Assembly Member Backus, for the record. I think what you're getting at, and I know, because I hear some rumblings of people not really understanding what you're referring to as dark money. And I think if you're referring to political action committees, for example, it's public record, there are public action committees that are mandated to comply with 294A with the Secretary of State, and they do disclose donors in excess of $1,000. So that is a public, this bill would not impact that, if I'm understanding you correctly.
No, I appreciate that.
Go ahead.
I'll try one more time. Yes, I get that. What I'm talking about is the organization, the PACs that don't have to currently disclose donors, and we might want to, going forward, change the law so that they do have to disclose. 294A allows that.
Thank you, Assemblyman Orlichter. I have Martin Fitzgerald, who's also been working with us on the bill, to probably answer more precisely what you're looking at.
Martin Fitzgerald, FITZGERALD with Nevada's Personal Privacy Rights. Excuse me. So dark money is a colloquial term, so I think when you get into the technicalities, that would be better ability to answer your questions. But again, it sort of depends on what it falls into. The Supreme Court has determined certain entities are exempt from that law, and so we can't override that. So those are federal questions. But on a state level, the bill completely exempts all campaign finance disclosures. So anything the state in its power that he wants to do with campaign finance disclosures can still operate, and this would not have no impact on that.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for bringing this. I always appreciate that we bipartisanly support privacy for our folks. My question is about the offenses and the money that is paid. I'm just wondering who pays that. Is it the agency that pays that? Or if there's an individual that puts all these names on a flash drive and takes it and discloses it, is it the individual that is responsible for paying those damages?
Thank you so much, Assemblymember LaRue Hatch, Assemblymember Backus. For the record, I believe the amendment that you have in front of you, I think we did do it as the person. And I just want to make sure, because you used a word that was kind of touchy that we used last session that created some
What, bipartisan? I'm sorry.
No. The word offenses. There is nothing, there would be no like type of criminal penalties with respect to this bill. It's purely a civil claim by the person that was harmed by the disclosure against the person or governmental entity that ended up like bringing it. But with respect to the level of damages, we've just limited that to a person.
And Martin Fitzgerald, Advanced Personal Privacy Rights. So the two things there, we're matching the penalties to the existing penalties in the Open Records chapter. And in question of who is held for the liability, it'd be the government entity, not the individual officer or employee.
Thank you for that clarification. So I guess my follow-up question is, let's say the governmental entity has done everything to protect this information, but they have a rogue employee that literally just steals the information and discloses it. Is the governmental entity allowed to then go after that employee after to recover the money that they just had to pay?
Martin Fitzgerald, Advanced Personal Privacy Rights. Again, there's a hypothetical here. The complexities would be interesting. So last session, the original bill we had penalties for those types of things. We had criminal penalties if an individual did things intentionally or recklessly. The local governments and state agencies requested that we remove them so that the individuals didn't have liability here, and so we did that at their request. Now, Assemblyman Hafen, point was, if they're acting in a criminal behavior, that is a separate thing outside of this law, and so different laws would govern the applicability of whether or not they could be charged with a crime for those types of things. But in terms of the victim, their action would be against the government entity, and then the government entity, depending on what the employee did, may or may not have reason to go after or hold accountable that employee for behavior. Again, if it was criminal, it would be governed that way. If it was not, then they would be unlikely. But I don't, it would, again, the hypothetical and technical components of that would answer that question better.
And if I may add, Shay Backus, for the record, I just want to clarify and correct my statement. I'll defer to Mr. Fitzgerald. I don't have my amendment in front of me, and we did change some language to just where a person, and so that's what I was recalling. I don't have my amendment in front of me, so I do defer to Mr. Fitzgerald on that.
Thank you so much. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. Just for better understanding, I want to know that right now, what are the laws regarding the non-profit organization? Is the information there? Is it public or is it partially private and you want to make it all private? How does it goes?
So there are components, and so in Section 2, Martin Fitzgerald, Advanced Personal Privacy Rights for the record. The way the bill is designed is everything that is in Section 2, Subsection 3 is all the allowable uses, the allowable ability to release or request information from nonprofits. And so that is current law. Those are the current practices. And so, again, we worked with stakeholders for months last session and for weeks this session to tighten it up and make sure that we're not we're allowing them to enforce the laws that the legislature has passed. So those are the allowable uses. The intent of this bill is to proactively prevent someone operating outside of those legislative mandates. So there is some question of what can be confidential, what cannot be in current law, but there's no real protections if someone releases information outside of the legislative mandate, there is limited recourse for a victim to come and take compensation, to hold accountable the government for operating outside of their mandate. And so what this is trying to do is not change anything in current law, but just put guardrails around it so that no one can operate outside of that, and a citizen has no ability to seek recourse and hold accountable a government entity that has operated outside of their legislative mandate.
Thank you.
Thank you. And I just want to clarify that for the intent of this bill, so members of churches, mosques, synagogues, temples also make financial contributions, which on paper could appear as a donor. But I just want to ensure that places of worship and belief are also included under that nonprofit definition in this bill?
Martin Fitzgerald, Nevada's personal privacy rights. It would depend on how they're structured. I mean, as long as they're operating under the 501c chapter of law, which is very broad. You know, where in politics people are used to 501c3s and 501c4s, but the chapter there is much broader. And so one of the things we wanted to make sure was inclusive of everyone that operates under that chapter, and not just political organizations, right? It's everyone operating who has a First Amendment right to gather and organize and express their beliefs, political, religious, personal. So the answer is, as long as they're operating or organized under the 501c chapter, then yes, they would be protected. If they're operating, if they haven't organized under that, this would be outside the scope of the law. There may be other protections in law for them, but this is just focused on protecting those who are operating under the 501c chapter, and it's all inclusive of that chapter.
Thank you so much. That's very helpful. Not seeing any additional questions, I will go ahead and open it up for testimony in support of Assembly Bill. I'm sorry, did you have something else to?
I was just going to testify in support.
I think you already have. So with that, I will go ahead and open it up for testimony in support of Assembly Bill 197.
Good morning, Madam Chair, members of the committee. My name is Ryan Leonard, R-Y-A-N-L-E-O-N-A-R-D, Government Affairs Advisor at Southwest Gas. Southwest Gas is in support of Assembly Bill 197, as 80% of our employees give to nonprofits directly from each of their paychecks. They contributed $2.3 million to local nonprofits across our service territory in 2024. As a company, giving back to the communities we serve is part of our culture. Assembly Bill 197 will provide protection to our employees' personal information. And on behalf of our 2,600 employees, we thank Assemblymember Backus for bringing this responsible legislation forward and kindly ask the committee for their support. Thank you.
Hi, I'm Caroline, C-A-R-O-L-I-N-E, Mello, M-E-L-L-O, Roberson, R-O-B-E-R-S-O-N. I'm here for Planned Parenthood Votes Nevada and Planned Parenthood Marmonte. We'd like to thank the bill sponsor for bringing this bill back again. We're supporting it just like we did in 2023 and really excited to see it move forward. Thanks.
Can you just wait one moment? I enjoy seeing you both at the table at the same time. Yes, smile for the camera. Thank you so much. Continue.
It's a day of firsts, right?
Yes, yes. Hopefully not last.
Good morning. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with the ACLU of Nevada. We have submitted a letter in support of AB 197, and we urge the committee to support this bill as well. Thank you.
Melissa Clement, for the record, M-E-L-I-S-S-A, C-L-E-M-E-N-T with Nevada Right to Life. I do have to correct my colleague from Planned Parenthood. This is the second time. We were in favor of this last session as well. AB 197 protects an individual's right to organize, make charitable donations, and join nonprofit groups without having those personal decisions publicized or weaponized by the government, regardless of viewpoint. Just the basis of our nation. This is First Amendment rights. And we commend the bill's sponsor for her presentation and for her dedication on this matter, and we urge your support.
Madam Chair, members of the committee, my name is Janine Hansen. I'm the state president of Nevada Families for Freedom. We supported this bill last time. We're supporting it again. There was a Supreme Court decision in 2021 which prohibited the state of California from collecting charitable nonprofit donor names in an attempt to say they didn't want them to commit fraud. This went all the way to the Supreme Court, and California's law was overturned. It's interesting to note that in that case, like we've seen today, people from all sides of the spectrum are supporting this, including the ACLU and the NAACP, as well as those that were involved in the lawsuit, the Thomas More Foundation and Americans for Prosperity. This is a critical bill. Many people, I don't know if many, but I have experienced problems because of my political positions. I was picketed at my office a couple times in this building. I've had to call upon the legislative police to protect me so that I could get out to my car when I was threatened. So we want to have a civil society and be fair and just and with one another. And this opens people up to discrimination and to persecution if we don't have laws like this on the books to protect those in their individual liberties to make decisions about different issues. And we really appreciate the sponsor in bringing this back again and commend her for her tremendous efforts in doing this. Thank you very much.
Kaylin Cardavani, Kaylyn Kardavani, Executive Director of New Day, Nevada. For many of the reasons highlighted above, we support this bill. Thanks.
Chair Miller, members of the committee, my name is Eric Cheng, ERICJENG. I'm the Executive Director of One API Nevada, here organizing and advocating for the Asian Pacific Islander Americans in the great state. At the end of the day, the privacy of nonprofit staff, members, volunteers, and donors should be respected and protected. I want to thank my assembly member, Backus, for AB 197 that strengthened what's already in our Constitution, the freedom of association, freedom of speech, and rights to privacy. This is something that is proactive, preventive, and also peace of mind for those of us in the work that calls this great state home and doing what we can to make it better. Thank you.
We will go down to Las Vegas. Please proceed with your testimony and support.
Good morning. Eddie Diaz, EDDIE-DIAZ. Thank you all for everything you guys do. Chairperson, esteemed members of the committee, my name is Eddie Diaz. I am the Strategic Director for the Libre Initiative Nevada, one of the largest Latino organizations dedicated to empowering the Hispanic community in Nevada and across the nation. On behalf of the Libre Initiative, I'm here to express our strong support for Assembly Bill 197. AB 197 will help safeguard the constitutional rights of individuals associated with nonprofit organizations. This legislation will require governmental entities to keep confidential certain personal information regarding donors, members, or volunteers. Esteemed members of the committee, as you know, protecting our First Amendment right is important. And if enacted, AB 187 will help ensure that individuals can freely associate without fear of unwarranted disclosures. Additionally, this bill will help encourage civic participation because when privacy is assured, more citizens are inclined to engage with organizations that drive positive change that does enriching our communities. Finally, AB 197 will help prevent unintended consequences by prohibiting the release of sensitive information and harassment or discrimination against individuals based on their affiliations. In conclusion, the Libre Initiative believes that the enactment of AB 197 will significantly benefit Nevada's Hispanic community by protecting individual freedoms. We respectfully urge the committee to support this bill and advance them through the legislative process without delay. Thank you for your time and consideration.
Members of the committee, my name is Ronald Najarro, RONALD NAJARRO. I'm the State Director for Americans for Prosperity in Nevada and for the Libre Initiative. Thank you for the opportunity for us to be able to express our strong support on behalf of AB 197. On behalf of all our thousands of activists across the state, we see the tremendous importance of this bill. It is about free speech, it's about freedom of association, and more importantly, it's about the privacy and fostering an inclusive democracy where a wide range of viewpoints are supported, ensuring the peace of mind that we have heard from testimony across the testimony here today. This is not a partisan issue, as you're well aware. This is about protecting the voices of all Nevadans and of all Americans. It's about safeguarding those freedoms that made our country great. For these reasons, we stand here in strong support of AB 97 and strongly send a great recognition of thank you to Assemblyperson Backus and Assemblyperson Hafen for showing the leadership and bringing this bill back. We support this bill like we did in the past legislative session. We thank you for your service and for all that you do on behalf of the great people of the state of Nevada. Thank you.
Good morning, Chair and members of the committee. Henry Rosas, External Affairs Manager at United Way of Southern Nevada. In last year alone, United Way mobilized 20,000 donors, 7,000 volunteers, and we have over 90 nonprofit 501c3 partners, all working to improve the lives of over 80,000 working Nevadans in Clark, Nye, and Esmeralda counties. We're thankful for the bill sponsor for not just including a wide array of perspectives and ideologies, but also including service providers as well. We stand in support to make sure that direct service providers serving diverse communities across our state and with diverse missions are able to do the work that they do best without unnecessary government overreach. So we thank you so much again, and we urge your support on AB 197.
Is there anyone else there in Las Vegas wishing to make testimony in support? Not seeing anyone, then we will go to the phone lines. Broadcasting, please open the lines.
If you would like to testify in support of Assembly Bill 197, please press star 9 now to take your place in the queue.
Good morning, Chair and committee members. My name is Carrie Durmick, and that is KERRYDURMICK, and I'm the Nevada State Director at All Voting is Local Action. We are an organization that advocates for policies and legislative priorities that expand voter access to build a democracy for all of us. We support AB 197, a bill that balances responsibility and power, provides necessary checks on state power, and prevents excessive state intervention. Essentially, AB 197 would protect Nevadans' First Amendment rights to come together and associate as they see fit. This is a needed protection for the robust community of nonprofits in Nevada, such as All Voting is Local Action, and this legislation will help defend the First Amendment rights for all of us. Thank you for your time and hopefully your support of AB 197.
Next caller.
Caller with the last 3 digits ending in 513, you are unmuted and may begin.
Caller with the last 3 digits, 513, please press star 6 to unmute your phone. You may begin.
Good morning, Chair and committee members. My name is Jessica Munger, M-U-N-G-E-R. I'm the Program Manager for Silver State Equality, Nevada's statewide LGBTQ+ civil rights organization. We are testifying in support of AB 197 so that our First Amendment rights to raise our voice, participate in democracy, and defend civil rights should not be subject to harassment and intimidation. Assembly Bill 197 puts into place appropriate guardrails to protect nonprofits from that type of harassment and intimidation and restrain potentially unethical office holders from engaging in unethical actions. By putting in these balanced protections, organizations like ours can continue to engage in their protected constitutional First Amendment rights, and the government can continue to engage in legitimate governance. This is a sound policy that treats all nonprofits, regardless of ideology, equally and makes Nevada's government a better actor. We urge your support. Thank you.
Thank you. Next caller.
Good morning, Assembly members and Chair Miller. My name is Ryan Vortish. That's Ryan, V as in Victor, ORTISCH. I'm calling on behalf of Silver State Voices in strong support of AB 197, and we'd also like to thank Assembly Member Backus for sponsoring this bill. Thank you.
Next caller.
Good morning, Chair and members of the committee. My name is Jenna Vella, Jenna, V as in Victor, ELLA. I am the Programs and Partnerships Director for Battleborn Progress. I urge you to support AB 197 to protect nonprofit workers, volunteers, and donors from targeted harassment. I have seen firsthand the devastating impact of inadequate protections. Just this past December, a former colleague had her personal information leaked on Truth Socials, including her family's phone numbers and addresses. Her father received hateful calls telling him his daughter should have been aborted, forcing him to change his number. My former colleague had to relocate out of fear for her safety. No one should face threats, doxing, or harassment simply for working at a nonprofit because our viewpoints differ. In a digital age, personal information spreads instantly, making these protections more urgent than ever. For the safety and security of our community, I implore you to support AB 197. Thank you for your time.
Thank you so much. Next caller.
Chair, there are no other callers to testify in support.
Thank you so much. Then I will open it up for testimony in opposition of Assembly Bill 197.
Good morning, Chair Miller, members of the committee. For the record, David Cherry, that's DAVIDCHERRY. I'm the Government Affairs Manager for the City of Henderson. I want to start by thanking the bill sponsor for taking time to meet with us to discuss the city's concerns regarding AB 197. And while we are still reviewing the sponsor's amendment, we believe it makes some important changes to the bill, especially when it comes to the collection of information required by law or for the exercise of due diligence and adherence to ethics standards. But one of our principal concerns still remains unresolved: how this legislation treats public records. As an entity subject to Nevada's rigorous Public Records Act, we are committed to transparency, while also recognizing that we have the duty to safeguard important confidential information. As proposed, AB 197 presents a catch-22, whereby a public entity risks costly litigation if it withholds specific information or it discloses this same information. We believe this justifies a higher threshold for penalties whereby a city or other government entity must be shown to have engaged in gross negligence and to have done so willfully. This willful standard already exists in NRS 239.310 and NRS 239.340 with regards to penalties for improperly withholding records. So we are simply seeking consistency as it applies to the improper disclosure of the records covered by the bill before you today. In addition, we believe the definitions in AB 197 regarding personal information are unnecessarily broad and will make it difficult for local governments to readily identify what they're being asked to keep confidential. Finally, we would ask that the provisions added to NRS 239B by AB 197 be included in the safe harbor that already exists for certain sections of this chapter and that offers protections unless there is a demonstration of gross negligence. We are hopeful that there is room for further negotiations on these issues and appreciate this opportunity to highlight the city's ongoing concerns. Our goal at the end of the day is to avoid the need for costly litigation by making the bill's language as clear as possible and honoring the balance local governments must maintain when it comes to transparency and privacy interests. Thank you.
Thank you, Chair, members of the committee. Nick Ciccone, Government Affairs Manager for the City of Reno. That's NICCICCONE for the record. I'd like to echo the comments of Mr. Cherry and say that we appreciate Assemblymember Backus's willingness to work with us and some of the changes that were proposed in the second conceptual amendment today. I appreciate and we can appreciate the intent of the bill as stated by the presenters and those in support, and can understand the protections the Assembly member is seeking for these nonprofits when it comes to rogue actors. That said, even with the exemptions, it will still require a significant amount of staff time when collecting and producing these records, and puts the city and our staff at risk. With a narrowed focus on bad actors and gross negligence, the city would be neutral on this legislation. Thank you for your time.
Is there anyone else here in Carson City wishing to make testimony in opposition? Is there anyone there in Las Vegas that would like to testify in opposition? Broadcasting, will you open the lines, please?
If you would like to testify in opposition of Assembly Bill 197, please press star 9 now to take your place in the queue. Chair, the line is open and working. However, there are no callers to testify in opposition.
Okay, thank you. Then I will open it up for testimony in neutral. Anyone wishing to testify in neutral will begin here in Carson City.
Good morning, Chair Miller and members of the committee. Jeff Rogan, R-O-G-A-N, on behalf of Clark County. With the acceptance by the Assembly member of the second conceptual amendment, which we worked with her over the past few days, Clark County is a neutral. This is something that we can live with. There are numerous exceptions to the general requirement that this bill imposes. One of the ones that we were stuck on and we worked through, and you'll find in the conceptual amendment, would be to subsection 23B, would be a situation where nonprofits are engaging in business in a county or a city or with the state. So if they're getting a business license, if they're applying for a permit, if they're looking for a land use entitlement, all of that information should be public so that people can know if or who is going to be operating that halfway house that's going into your neighborhood, for example. And so we thought that was an important exception to include, and thankfully the Assemblywoman agreed, and you'll find that in the subsection that I mentioned. There are other parts of this conceptual amendment that we thought were important for clarifying purposes. I think Assemblymember Cole brought up one of them, which is whether the increasing penalties are per person or per offense, and that is clarified in this conceptual amendment. So with those changes and the additional changes that have been made since last session, we're satisfied with the bill, and we respect the position of our fellow municipalities and their position on this, but we're in neutral on this. Thank you.
Sherry Powell, Ladies of Liberty, P-O-W-E-L-L, Victims' Rights Organization. I'm neutral. I really didn't come for this for today, but I would just exercise due caution when there are individuals who are operating as 501c3s or nonprofits, that you don't go into that arena where they are not disclosing things that they should be and acting inappropriately. I'm neutral because my organization are victims. They are protected under the victims' rights. So I don't have to worry about who wants to look at what. And so I would just exercise caution, as you know, former Assemblywoman, questioning on her recent prosecution, for inappropriate transferring of funds. Not familiar with the case all the way, but I'm probably going to do some research into it because I'm very familiar with her. And so I find it very bizarre that that type of prosecution actually took place. But you're talking a government entity who got into a victim's information and contributions. So I find that just really interesting. So I would just say you're walking a fine line of protecting inappropriate behavior versus trying to keep people's privacy. And there are stalking and harassment laws. My name is Sherry Powell. Once again, Ladies of Liberty, you can find me wherever you want to. And if you ever have somebody who harasses you for any reason whatsoever, you just give me a call, because I've got about 40,000 victims who will be more than happy to protest with you. Thank you.
Thank you.
Good morning, Madam Chair, members of the Assembly Judiciary. Tanya Brown, TONJA, BROWN, private citizen today. Normally, I wouldn't have said anything, but a lot of people don't know some of the things that I have been involved with over the years, and I have sat on and board members on nonprofits and 501c3s. And something that has never been touched on or anything else, and I think this should be part of the discussion, is hostile takeovers and the damage that can be done by that. I will tell you that back in 2013, a bill was passed. It was a beautiful bill. And it was our bill that started this originally. Everybody voted for it. But in the process, there were other organizations. We all come together as whole for a great cause. Okay, I'm not going to say the organization, or off the record, I will. I will tell you that there came a point in time where these other organizations were trying to take credit of what we had accomplished. Okay, and I can tell you that during a conversation we had, at the time it was Governor Brian Sandoval, and he had approached us about an event that had raised quite a bit of money. We had no knowledge of that, nothing. We weren't even invited to the event. And to this day, we don't know whatever happened to it, but these other organizations thought that we were the ones who received the money. We never saw the money, we never got the money, and it has done harm to that organization I used to sit on. And so I think, and when we tried to look into where did this money, there were no answers anywhere. So when you're looking at organizations coming together and wanting the credit or whatever, sometimes I can just tell you that the backstabbing from other organizations, and they're all great organizations, can do a lot of harm. But I wanted you to know this, and I will tell you that the
Ms.
bill
Brown, we're
passed.
over time.
Okay, thank you. But think about hostile takeovers and the damage that can be done, and there's no resolution, and there is no answers.
Thank you, Ms. Brown. Anyone else here in Carson City that would like to testify? Anyone in Las Vegas wishing to testify in neutral? Broadcasting, will you open the lines, please?
If you would like to testify in neutral for Assembly Bill 197, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, you have no callers to testify in neutral at this time.
Okay, thank you. Then with that, I will welcome the bill sponsors back up for any final remarks.
Thank you so much, Chair Miller, Committee on Judiciary, Shay Backus from Assembly District 37. I wanted to just touch on a couple opposition points. Normally, I'd waive closing argument, but even with Ms. Brown's testimony, it reminded me also a letter that may have been circulated to the committee that may also make its way onto Nellis. Concerns about nonprofits and contracts that may be with our government. Specifically, there's almost 3 different exceptions under our subsection 3, under section 2, looking at directly goes to contracts between a nonprofit and a governmental entity. In no way is our bill intended to somehow hide nonprofit information when they're contracting with the government. When they do that, obviously they're availing themselves to get government resources. That stuff becomes public. Also, you can also stretch it under J. Those are contracts with DHS, as well as subpart M. That is our Ethics Commission request for such ability to have information public when there are relationships with nonprofits. So I wanted to highlight those just because there have been concerns and exemplars raised of what this bill would do, which it does not do. So I wanted to make sure everyone was aware of that. With that, I'll turn it over to my colleague.
Thank you, Madam Chair. And I did want to just bring Gregory Hafen for the record, the attention that on the subject of having to redact information that's currently under statute, there are certain things that have to be kept private in the release of public information. And so to us, we don't think that it's an additional burden on the municipalities to say this information also has to be redacted, since they already have to go through all the documentations to ensure that the other information is not being released. So respectfully disagree with the opponents to that, but because there are already certain areas of other statutes that do require the same thing.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 197. Next on our agenda is public comment. So anyone wishing to make public comment about anything under the purview of this committee, but not directly relating to the bills heard today, please come forward.
Tanya Brown, Tonja, BROWN, Advocates for the Inmates and the Innocent. On, I believe it was Wednesday, Assembly Bill 63 was heard. And I was surprised to hear about the sponsor, Attorney General Ford, not wanting dealing with exonerations and posthumously that no compensation. There are 5 new members on who've been elected. Some of you were not here in 2019, came afterwards, and I just want to give you a little info and go back and check, but I think this is important. During the compensation bill hearings and everything, Judge Douglas Herndon, who is now your Supreme Court Justice, he gave testimony on behalf of the compensation dealing with Fred Steese. Fred Steese had spent many years in prison, and through the help of through the Innocence Project, and apparently Judge Herndon's daughter is the one who became aware of what had happened in that case, in which there was some exculpatory evidence that was withheld from the defense, placing Mr. Steese had lived. It was in another state at the time of the crime. And ultimately, it went into court. It was about ready to be decided by the judge. The DA goes to Mr. Steese and offers him a carrot of his freedom and said, listen, if you take an Alford plea, we'll let you out. And after serving nearly 20 years, he took the deal. And so Judge Herndon come before the committee, testified as to that, because he wanted Mr. Steese to be paid the compensation. And according to the law, because he took an Alford, he could not apply for that. And I just want you to think about this when these laws are. When a person passes away, their families have struggled
Ms.
just
Brown,
right along. Yes,
we're over time.
Oh, and just one brief thing. If you take a look at the lawsuits where they talked about the 1983, all those.
Ms. Brown, we're over time. Thank you so much.
Thank you.
So once again, Sherry Powell, and I don't normally sit next to Tanya Brown either, because I am not fans of inmates. Sorry, don't care. You commit a crime, you do your time. I work for victims, but I also spoke prior to on the DNA bill that Ms. Brown brought in 2008. 17, okay. Because I believe if you are an innocent person and you have factual innocence, that would be everybody here. And if somebody maintains you in prison or does not bring forward the evidence that would set you free, shame on them, and maybe they should do a few years in prison as far as I am concerned. So with this particular bill, I'm very familiar with the bill that she was talking, or the situation that she was talking about also came up for parole, and individuals who had full knowledge of this man's innocence withheld it, but not only that, voted to maintain him in prison. Shame on them. And so for me, you become a victim when you are innocent and people put information out there against you that is inaccurate, incorrect, and illegal. And so I would say that they should be compensated if they pass away, walk out the door and have a heart attack walking over and picking up their check. Shame on the government for putting them in prison.
Thank you so much. Is there anyone else here in Las Vegas, here in Carson City, wishing to make public comment? It appears that everyone has also left Las Vegas. Broadcasting, will you open the lines, please?
If you would like to provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, for the record, Advocates for the Inmates and the Innocent, ANNEMARIE. GRANT. I had the opportunity to listen to AB 63 presented by Attorney General Aaron Ford, and I was surprised by his comment that there would be no compensation for the wrongfully convicted who have passed away. I know how difficult this is for the families. Ms. Brown may not be able to say anything, but I certainly can. I've seen the negative treatment and the negative impact it has had on Ms. Brown's life, her brother's wrongful conviction, late night nasty voicemails, former law enforcement officers going out of the way to smear Ms. Brown's name at legislative hearings, the names that she's been called, but most importantly, the pain in her eyes that I see every day, having to live with the injustice that's been perpetuated against not only her brother, but in turn, her entire family. Over the years, she has advocated for her brother, for posthumous exonerations, and for other inmates, but people fail to realize the lost time and the consequences and negative effects it's had on her family. As she's focused on clearing her brother's name, she's lost time with her husband, her children. And I just want to read from Herman Lindsay, who is the Executive Director of Witness to Innocence. We are writing today to say that had we passed away before being exonerated, we would still want a chance to have our names cleared. A large part of our suffering on death row was knowing the pain it caused our loved ones. Some of us had children who had to grow up with the world saying their mother or father had committed a heinous crime. When we were exonerated, the relief and healing it gave to our loved ones was amazing, and being reunited with them was our greatest joy. Those innocent people who died before being exonerated will never have a chance to experience that. But at the very least, they should have a chance to clear their names to bring relief and healing to their loved ones. And I would just like to mention that no person who has been exonerated in Nevada has, when they filed
Ms. Grant, we're over time.
lawsuit, they have not chosen to name the state because the state did the right thing.
Ms. Grant,
and
we're over
compensated
time,
them.
please.
Thank you.
Thank you so much. Broadcasting next caller.
Chair, the public line is open and working. However, there are no other calls who wish to provide public comment.
Thank you so much. With that, I will go ahead and close public comment. And I generally don't respond to people making public comment, but I think I speak for the entire committee when I say, Ms. Brown, we all do recognize and appreciate your passion and your work. Absolutely. With that, we have concluded our business for today. So I will adjourn this meeting, and I will see you all at 9 a.m. on Monday morning. Have a great weekend. Oh, I can take it back quickly. You did, 9 a.m., yes.